Okay, so we just finished discussing the sexual harassment of Governor Andrew Cuomo, that he committed, I should say. And now we need to look at what's happening in the Supreme Court. So basically, the lead into this is Ted Cruz and Josh Hawley, as well as Mike Lee, who few people talk about really. They have petitioned the Supreme Court to overturn Roe versus Wade in a recent Mississippi court case. So what I'm going to do in this segment is break down the amicus brief that they filed. Now, the first thing to note is, what is an amicus brief? Amicus, and I'm saying amicus, I know that technically it's amicus curiae or whatever in Latin, and it means friends of the court, or friend of the court actually in Latin. Technically, it's an amici curiae because amici is friends of the court and two people are filing. I don't care. It doesn't really matter. That being said, they are filing an amicus brief, which is something that people send to the Supreme Court so that they can hear different sides of the story, so that they can hear how a court decision will affect them. So they're filing that in order to get the Supreme Court to listen to them, basically, is what the point of an amicus brief is. Okay, so there is that amicus brief being filed. I also want to mention another amicus brief, which is being filed by primarily Governor Henry McMaster of South Carolina. It's probably been sold to you as the DeSantis amicus brief, DeSantis being the governor of Florida, but DeSantis didn't write it. It was Henry McMaster's office who came out with it first, and DeSantis signed onto it, but for some reason, because the media can't get enough of DeSantis, they're putting DeSantis' name on it. Okay, regardless, let's look at both amicus briefs. Let's look at the Mississippi court case and the court's filing of certiorari. Certiorari being, sometimes called cert, being when the court grants a writ of certiorari. What they're saying is that they're going to hear a case. That's basically what they say, and then they're going to say why they're hearing it. So first, let's discuss two major important abortion cases that are very often confused. So the first one is Roe v. Wade. Roe v. Wade was based on the question of whether the Constitution recognizes a woman's right to terminate her pregnancy by abortion. So the argument was that, so first, Jane Roe, Jane Roe is like a fictional name. It's like John Doe or Jane Doe. It's Jane Roe. And she filed a lawsuit. I think actually, I forget her name, but she eventually became a pro-life activist, actually. But Jane Roe filed a lawsuit against Henry Wade, who was a district attorney of Dallas County, because she thought that a Texas law that made abortion illegal was unconstitutional. So why was it unconstitutional? Because she said it was too vague, and it abridged her right of personal privacy. Personal privacy was established, I believe, in Griswold v. Connecticut by the Ninth Amendment, but also by the First, Fourth, Fifth, and 14th Amendments. So the argument was that the Constitution recognizes a woman's right to terminate her pregnancy by abortion. Now, what eventually occurred was a 7-2 decision for Roe, and the argument was that the Due Process Clause has the fundamental right to privacy, and that right to privacy protects a pregnant woman's choice about whether she wants to have an abortion. So the important part, though, is that the right is balanced between both the government's interest in protecting women's health and protecting the potentiality of human life. So the argument was that the Texas law went too far, and it actually abridged women's health. It damaged it, and as a result, the Due Process Clause protects against the state action against the right to privacy. So that was Roe v. Wade, and it really was an issue because it really broke down into a lot of different weird things. The trimester system was created in Roe v. Wade. The first trimester, the state can't regulate. The second trimester, the state can only regulate if it's reasonable. And the third trimester, the state can regulate or prohibit them entirely. So that was always controversial because it seemed as if it was legislation in a way. So Roe v. Wade was eventually, I'm not going to say updated, but parts of it were modified in the case Planned Parenthood versus Casey. So the question there was, can a state require women who want an abortion to obtain informed consent? There were just a variety of different guidelines that were put on abortion, like notifying their husbands, informed consent, a few other ones, obtaining parental consent, waiting 24 hours, just a variety of different things. And the argument was that that would violate their right to abortion. So that was the question. The conclusion was actually 5-4 in favor of Planned Parenthood, where they say that Roe still holds. However, a lot of the Pennsylvania provisions also hold. And there's now a new standard that says undue burden. It's called the undue burden standard. And the undue burden is defined as a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. So the only provision to fail the undue burden test was the husband notification requirement. And actually, it was basically overturning all the other, it was basically upholding all the other restrictions. So the idea was that, yes, you can actually restrict in certain circumstances as long as it doesn't pose an undue burden to women seeking abortions. So, okay, now let's look at two different amicus briefs, one filed by Josh Hawley and Ted Cruz, which I will probably mention in the title as Cancun Cruz and Sedition Hawley, because I think those are kind of funny names. Okay, so let's see. The first thing is, actually, let's go to the Hawley amicus brief first. So the first part of the argument is, so number one, this is I believe it's a 33-page amicus brief. Most of that is references. Most of that is tables of contents. And you can actually sort of scroll down that. So it's only really around like 10 pages if you read it, because the weird way that briefs are filed is that they're filed in the specific type of paper, which is actually much smaller than other papers. I don't really know why that is, but it just is. So it's pretty thin and pretty small, so it should be a pretty quick read if you're a fast reader. But if you want to consider every point they make, read it slowly. Okay, so I will consider every point they make. I did read both briefs, and I did find both of them quite interesting, and at the end I'll give you my assessment of both briefs. Okay, so the first argument comes from Cruz and Hawley, and it's an argument from the fact that Casey is unworkable, and as a result, it needs to be reconsidered. So first, let's look at the standard of stare decisis. Or stare decisis, actually. It's pronounced a lot of different ways, but I say stare decisis, and some people say stare decisis, or something like that, because, I don't know, because they don't speak Latin, I guess. I don't either, but it's a bit silly to say stare decisis, right? Anyway, regardless, basically the point there is that stare decisis is the idea that the court should generally follow precedent. So the major thing that they say is, okay, the court should follow precedent, that's true, but that doesn't hold if the precedent is unworkable or unpredictable, as they say is true for Casey. So that's a little questionable to me. Unworkable and unpredictable makes sense if, it hasn't been in place for 30 years, but it has. So maybe removing it would be in itself unpredictable or unworkable. So the argument, though, is that it's not absolute. Stare decisis is not absolute. And that precedents that are historically unworkable are not entitled to stare. Now, the other important point that they make is that the Casey test itself is unworkable. So they start with, if a precedent is unworkable, it's not entitled to stare, meaning it's not entitled to be upheld if it's unworkable. Then they move to, okay, so that's true. That means the test in Planned Parenthood versus Casey, which is the undue burden test, that is unworkable. So they're trying to not just overturn Roe, but they're also trying to overturn Casey, which is a more moderate Roe. So that's pretty important to remember. Now, the argument is that it was recognized early on that it was unworkable, and that it continues to be unworkable to this day, and that it will be in the future unworkable. So they comment on a lot of different points. So they basically say that it abandoned Roe, it overruled two prior precedents, and applied a new undue burden standard, which was inconsistent to other laws. The other important thing is that, number one, the dissent was fairly strong, and number two, there are other cases where the undue burden standard has actually continued to evolve, and it seems to be unworkable from that standpoint. We're going to discuss these two cases, hopefully in a different episode, Hellerstedt and Russo, which were actually recently decided. And the point there is that in both of those cases, there was a change in Casey. So the fact is that Casey isn't a great precedent because lower courts are unable to understand how Casey applies to certain standards. And as a result, the undue burden standard is a standard that needs to be overturned or reworked to an extent that it basically is completely unrecognizable to how it is today. So the argument is that Casey is unworkable. It's not long settled doctrine, and it's flawed, and as a result, it should be overruled. I think that is a fairly strong argument against Casey. I think it's probably going to be the argument that works, if an argument works, that overturns Roe v. Wade or Planned Parenthood versus Casey. Okay, so if we move on from there, we can look at the McMaster case. So something important, actually. Let me actually go back to the Cruz briefing, because it is important to see the impact statement, or the interest statement, excuse me. And the interest statement here is just generally that they want to promote the clarity and consistency of American constitutional law. That seems a bit silly to me as a amici interest, but I mean, I guess that works. So let's move on to the McMaster case. The McMaster case seems to have, or the McMaster brief, excuse me. The McMaster brief has a much stronger interest statement because McMaster signed the South Carolina Fetal Heartbeat and Protection from Abortion Act. So that would be violated by, or that would probably violate Casey. So we need to look at that in a different light, and that light could be the light that the Supreme Court would rule in this upcoming Mississippi case. So the points that McMaster makes is, number one, the 14th Amendment does not include the right to terminate the life of an unborn child. So they're using an originalist argument here. They're saying that when it was originally written, that was never the intent of the 14th Amendment. Then the next thing is that Roe and Casey upset the constitutional balance between states and the federal government, because the Constitution creates a federalist government, a system of dual sovereignty, as they say, and that the political branches of the federal government are infringing on the states at this point. And basically, the argument is that the reserve powers, which are the powers that are given to the states by the Constitution under the 10th Amendment, that those powers are being taken and moved into federal constitutional law grounds. And that seems to be something that they consider to be against what the Constitution was founded on. And then the final thing is that abortion to the states is faithful to the 14th Amendment's original understanding. So they're using the 14th Amendment which also, by the way, the 14th Amendment was the one that underpinned Roe v. Wade with the Due Process Clause. And of course, because Roe v. Wade underpins a lot of other court cases, Planned Parenthood v. Casey. So the takeaway here is that they're using Amendment 10 and Amendment 14, as well as the entire Constitution, the general ethos of the Constitution, to say no to Roe, to say nay to Casey, and to basically push aside the abortion restrictions that have been in place for the restrictions on restricting abortion, I should say, that were put in place in the 70s, sort of lessened in the 90s, and sort of continuing until today. So these different problems are actually pretty big when you're at the Supreme Court and you're a 6-3 Supreme Court, 6 conservatives, 3 liberals. Will Roe survive? And I think the question really does come down to Chief Justice John Roberts. Will it survive? I think yes. I am going to put my hat in for yes. I think it will survive, because I think that Chief Justice John Roberts is really an institutionalist when it comes down to it, and that he will not let the Supreme Court overturn Roe v. Wade wholeheartedly, rather. And that so there will be, of course, a backsliding in abortion rights. I think that's true. But I don't know whether you'll see the complete, destruction of abortion restriction regulation from the federal government. I think that's probably not going to happen. But it could. It could, and we do need to be aware of that. And of course, this is one of the major reasons why we say, why us Democrats say it's important to vote for the Democrats, because of the Supreme Court. And a lot of people say that's not true. Well, actually, we're seeing a lot of the pushback now because of the conservative ownership of the Supreme Court that occurred under Donald Trump. And yeah, so we will continue looking at Roe v. Wade. We will see what happens in the future with Roe v. Wade. If you're not subscribed already, subscribe to us on YouTube at In Progress with Raymond Perez, and look for me on Linktree at linktr.ee/RaymondPerez. After this, we will try to see what the GOP really believes. Hint, the answer is nothing.